Now, there are renewed calls to reform the family court system after claims that some parents are waiting up to 2 years for formal access rights to their children after a breakup.
Some areas of our region are struggling with a heavy backlog of cases. Nick Smith reports.
The breakdown of a relationship can be a hugely stressful experience, but the process can be much more complicated when children are involved. Family courts can determine access rights for either parent, but in the wait for a hearing, the primary carer often holds the power and control of when and where their ex-partner can see their children. Colette Stroud is a solicitor in family law for a firm in Whitley Bay and says there are huge delays in the court system.
There are considerable backlogs in the family court in the North East. You are encouraged by your lawyers generally and indeed by the court system to try and reach agreement, whether that's by working with a family mediator or if you've got two sensible family lawyers working together, then they will work very hard to come up with a solution. The difficulty is that with family disputes, it's often driven by emotion.
John Denby spent years having restricted contact with his own children after separation from his wife. His son and daughter were under 10 at the time. He says without a firm plan in place for access in the initial stages of a family breakup, reliance on the courts can have a devastating effect on the parent who isn't the primary carer.
Heartbreaking is the immediate word that comes to mind because I was a very hands-on, committed father. Suddenly they're gone from my life. You would be walking down the road and you might see a father taking his children to school, and it really hurt that you could no longer be a father to them. We would like to see a less adversarial system because we think that generates conflict. The delays in the system are very damaging and that's contrary to a child's best interests.
Some countries like Sweden have a presumption of shared parenting and try and facilitate equal access from the point of separation. But family law experts like Lucy Reid say there are important factors to consider which do often need the presence of a judge.
It's to ensure that the welfare of children is properly identified and prioritised, and that includes their safety. Sometimes parents don't agree about whether the other parent is a safe and able parent. So there are some cases where it's absolutely right for the court to say, no, contact should be restricted. But there are also a large number of cases where contact can and should be promoted, and it is promoted, and orders are made by the family court.
The Ministry of Justice says the backlog in the family courts is reducing but remains too high. So they are promoting methods like mediation to settle child access and visitation. A move welcomed by advocates for a system where separated parents can properly share involvement in their children's lives. Nick Smith, ITV News.